Hello and welcome to the BLC Box. My name's Steve Terrett and I'm delighted to be joined in the box today by Scott Matthewson. Now, Scott wears a number of legal hats, let's say, because he has a number of roles within the legal system, and we'll be chatting about each of these roles today. Firstly, Scott is a barrister. He's a member of Chambers at 42 Bedford Row, and he's the head of the clinical negligence team there. So that means he handles all kinds of negligence cases, but in particular, he specialises in claims regarding medical or clinical negligence and personal injuries. He's been recognised as an outstanding advocate by all of the leading lawyers' rankings, and he's been involved in many important and very high-profile cases. Secondly, Scott is an advocacy trainer for Inner Temple. Now, for those of you who enjoy Star Wars films, this is the advocacy equivalent of the Jedi Council. And he's taught advocacy to lawyers and advocacy trainers in South Africa, in Hungary, Poland, and at the International Criminal Court in The Hague. But finally, Scott is also an assistant coroner. Now, coroners conduct official inquests. And because the terminology and even the concept of coroners and inquests is something that some of our viewers may not be familiar with, I thought it would be interesting for us to talk to Scott about his role as a coroner. So, Scott, thank you so much for joining us today. Welcome to the BLC Box.
It's a pleasure to be here. Thank you.
I mentioned in the introduction that you're a barrister. Could you explain to our students what is the essence of the difference between barristers and solicitors?
All right. Well, there's a simple version and a complicated version. I'll start with the simple one. A barrister is essentially a court advocate, and they're usually a specialist in their area. And a solicitor, by contrast, is generally an office-based lawyer. So it's the person that you would go to off the street and see and talk to if you had a legal problem. And historically, you couldn't go directly to a barrister. You had to be referred to a barrister by a solicitor, a little bit like a general practitioner, a doctor, referring you to a specialist in a hospital. Now, things have changed a bit now, but I think the easiest way to think about the distinction between solicitors and barristers is that the solicitor prepares the case and the barrister presents the case in court. And of course, in this country, we wear wigs and gowns when we do so.
Oh, this is always a question that students ask. Why are you wearing wigs and gowns? What's the point of it?
Well, it's historical now. I think some people feel that it gives a certain degree of anonymity when you're in court. I'm not completely convinced about that. I think you can recognize somebody who's not wearing a wig or when they are wearing a wig. But I think it's a charming tradition. And actually, the most barristers you speak to could take it or leave it and aren't particularly bothered by it. But we took a poll years back of our clients, particularly criminal clients, and they are very, very keen on us retaining the wigs. Clients feel that they're getting their money's worth and they're getting a proper brief if you're wearing a wig.
In commercial cases, they're getting rid of or largely have abolished the tradition of wearing wigs. Does that apply to your cases too?
Yes, they are not worn in certain cases. So, for example, the obvious example is in the family cases when you've got lawyers talking to children and so on. It's obviously not appropriate to be wearing a horsehair wig with a gown because it's just intimidating. And I think in other areas of law, commercial law, they've dispensed with wigs. But in my jurisdiction, in the Queen's Bench Division, and certainly in the criminal division, we still wear wigs when we're in open court.
Now, I mentioned at the beginning that you amongst your specialities, then medical negligence or clinical negligence cases are perhaps at the fore. And those cases will almost inevitably, or at least very often, involve expert witnesses.
Yes.
Now, how do you have a medical background? Do you have medical training?
No, not at all. And there's a saying that the only thing worse than a lawyer who thinks he's a doctor is a doctor who thinks he's a lawyer. But in my experience, the most effective way to work with doctors is always to remember that you are not one yourself. And the same goes for the doctors. And we look to each other to guide, the doctors guide the lawyers as to the medicine, and the lawyers guide the doctors as to the law. And that works very well. But yes, all of the areas of law that I work in have the common theme of medicine. I come from a medical family. My father was an orthopedic surgeon, but I wasn't clever enough to be a doctor, so I had to become a lawyer instead.
So as an advocate in a case, then when you're questioning expert witnesses, does it demand a different approach from you as a lawyer, as opposed to when you're asking questions of non-expert witnesses?
Absolutely. Yeah, there's an enormous difference in the technique and the skill. I think that boiled down to its essence, what you've got to remember is you're asking questions of a person who knows what they're talking about and you don't. And so really that's the starting point. How are you going to go about cross-examining somebody who can really run circles around you in terms of the area of expertise if they wanted to? And really, it's cross-examination, which is what we're really talking about, I suppose. Because one of the most important things about cross-examining a witness is to maintain control of the witness. And the moment you lose control of the witness, it can be the making or breaking of a case. And it's very, very difficult to regain control. So the short answer, how do you cross-examine experts, is very carefully indeed, is the first answer. But to be a bit more helpful in practical terms, what do you do? Well, you start with your preparation. Preparation is the key when dealing with experts in court. You just simply have to be prepared. And what that means is reading the report. Now, very often you won't really understand at a first reading what it is that you are reading, and it can be very intimidating staring at lots of medical terms swimming around the page and trying to get a handle on it. But probably the best advice I can give is just start reading, start taking notes, identify any words that you don't understand, look them up on the internet. And after you've undertaken that process, perhaps twice or maybe 3 times, you'll have an idea as to what the report is saying, but you'll also have a list of questions at that point that you want answering. Mm. The only way to get on top of all of that material is then to meet your own expert. And then you go through that expert's report and the other side's expert report with them. And the key to that conference, that meeting, is to not be afraid to parade your ignorance. You mustn't pretend that you know what you're talking about. You mustn't assume anything. And if there's an acronym or a word that you don't really understand, it's a big mistake to pretend that you do, because the doctor's rattling through his advice and evidence. So don't be afraid to say, I'm sorry, to the expert, and he or she will be delighted to explain it to you. Say, could you explain what you're talking about in this paragraph in a way that a reasonably intelligent 15-year-old would understand it? They usually smile broadly at you and are delighted to go through it. And it's only by making it clear that you're not an expert and that you're ignorant that you can get them to teach you. And that involves listening for the most part, asking the odd question, but you learn what the evidence is from your expert. The next stage is to find out where the weaknesses are in your case. And again, your expert, your own expert, is the best person to ask. I often just say, what are the weak points in our case? What do I need to be worried about? And when they explain them to you, you say, how are we going to get around this? Why isn't it important? By the end of this conference, you should have enough material to really start putting together your cross-examination. And then it's a matter of getting into court. And a lot of cross-examining experts is to do with confidence. Confidence comes from A, being on top of the material, but B, keeping it short and sweet. Never ask an expert the same question twice, because you'll give them that split second to have a think about giving you a better answer or one that undermines the good evidence that you've just got. But carefully, very careful is the advice I would I would take. But above all, be brief. You get in and out. It's a smash and grab with an expert. It's not trolling down the aisles at leisure for hours and hours looking at everything on the shelves. You've got to get in and get out, like you're a smash and grab raider.
That sounds like the voice of experience. Have you ever seen any expert testimony and a lawyer questioning an expert? Have you ever just seen it completely fall apart in court? And if so, what was the reason?
Well, I have seen it quickly fall apart, and I'm sorry to say that it's fallen apart in my hands. So I've had my my backside kicked by an expert many a time in court. And I think it's really avoiding that situation where you're exploring an area with an expert. Really, the times that my cross-examination has fallen apart, or the parts of it that haven't gone so well, you can usually trace back to just that loss of control, where I haven't really understood the issue sufficiently well to be able to ask the next question and confidently know what the answer is going to be. And very often in those circumstances, the best thing to do is nothing, rather than put your foot in it and get yourself wound in. But no, I'm afraid I've probably made every mistake there is to make in the book, but that's part of the learning process. And the important point then is, when you have a rotten day in court, to reflect on it and think about it and work out why it didn't go so well, and talk to colleagues about it and ask them how to fix it. And my experience at the English bar is that people are incredibly generous with their time and their advice, and they're always happy to sit you down. On one occasion, I asked my opponent where I went wrong, and he very kindly took me through it and explained, what was going on. He could see that I was feeling a bit glum after the trial. But I think you can always improve. I don't think I've ever seen the perfect cross-examination. There's always room for improvement.
And one of the things that we'll talk about a little later is your role as an advocacy trainer. But I'll put that on hold just for the moment. I'd like to talk maybe a little bit more about expert witnesses and then about your role as a coroner. I remember when studying evidence at university many years ago, the teacher saying that there's a problem with expert witnesses in the way that it's structured, because witness number one, who is an expert and clearly knows more than the judge, would come in and tell the judge that the answer is X. And then everyone would wave goodbye to that witness, and the judge would be fairly convinced that the answer was X. And then we would wheel in witness number two for the opposition, who would say, no, it's Y. And they would be also very, very convincing. And in order to remedy this problem, there was a rather sexy sounding change to procedural law by the introduction of something called hot tubbing. What on earth is hot tubbing, and what is it meant to do that wasn't there before?
All right, well, I've not ever been involved in hot tubbing, but I think I know what it is, and I think I know what the purpose of it is. I think in short, it's where a group of experts, two or more, in the same or sometimes different fields, openly discuss the case and are asked questions either by the judge or by counsel. And both are given an opportunity to put their side of the argument and explain why. But not only that, as I understand it, it involves the experts themselves to some extent being able to exchange ideas. Now, it ought to be possible for the two advocates, the two barristers between them, to understand the issues, identify what the problems are, and conduct the cross-examination in a way that enables the court to understand it. But I have been in cases, and certainly seen cases, where you've got an advocate who's got a certain idea about what the case is about. His opponent or her opponent's got a slightly different view on that point. They ask slightly different questions going to different points, and it can end up being rather confusing for a judge. I think hot tubbing is the idea that you just let the experts get on with it, and between themselves explain themselves and work out what the problem is or what the answer is. And I think it would work particularly well in the medical setting. And the reason I say that is this, that doctors are very, very used to discussing cases. They have multidisciplinary team meetings at hospital. They challenge each other. One doctor, one consultant will say to another, well, that what you're proposing isn't going to work because of X, Y, and Z. Mm-hmm. And so doctors are used to criticizing each other constructively. They're not afraid to give their views to each other, and they're not shy about it. And they're not afraid to back down and concede a point when they're persuaded by a colleague. So they do it as part of their working life every day. They have multidisciplinary team meetings, exchange ideas, and try and get to the bottom of the problem. And if hot tubbing works in that way, in the right case, I think it could be very effective, and probably much more effective than the traditional route. And it's a little bit like at conferences. Often I'll have a conference where we have 5 or 6 different experts in different areas, and they've all provided their reports, but we're left at the end of it really not understanding what the nub of the case is. And usually I ask a few questions at the beginning, and then I just sit back and let them discuss it in front of me. And, you know, an animated discussion usually follows, and they usually get to the bottom of it together because they learn from each other. What one expert will say to the other, I didn't realize that. Well, in that case, this is the consideration. And by discussing it and talking it and throwing ideas around, they usually get to the bottom of it, and it's usually very helpful. So I think it's a good idea.
If you could, let's say, Back to the Future style, go back and meet yourself on that first day that you donned your robe and your wig, and you could give yourself some piece of advice about law or being a lawyer, what would you say to yourself?
I think, frankly, the first thing I'd say to myself is heed the advice of my first pupil master, is what they were called in those days, but pupil supervisor now, which was, they told me to put away half of my money for the tax man and my bills and only spend the other half. And I didn't take that advice. It came back to haunt me later on. So that's a bit of practical advice. In terms of advocacy, I think my advice to my younger self when in court would be get on with it. Just get on with it. Judges, generally speaking, want to get it right. They just want to know what it is that you want and get the right answer. And if you go into court thinking to yourself, what does this judge want to know? Well, most judges want to know, 1, what are you asking me to do? 2, have I got the power to do it? And 3, why should I do it? And you really can't go much wrong if you stick to those principles. That's what the judge will have in his or her mind. And if you set about trying to address those at the outset and not rushing it, but getting to that quickly enough so that they can see where you're going, then I think that would be the advice I'd give myself. Get on with it.
That's fantastic advice. I shall heed it and get on with the rest of the interview. I've mentioned that you're a coroner. Maybe let's just ask a very general, open question. Could you explain to us what a coroner is and what's the function of a coroner?
All right. Well, it's complicated and it's simple. I mean, in its simple form, the modern coroner in England and Wales is a government official, a local government appointed official, who has the power to order and carry out investigations into how people died. So they have to answer these 4 questions. Who is the person that has died? When did they die? Where did they die? And how did they die? And in most cases, the how question is just what were the facts that immediately led to death. Mm-hmm. So that's what a modern coroner does. But it's an ancient jurisdiction and quite an odd and unusual jurisdiction in some ways. It originated, I think, shortly after the French invasion of Britain in 1066. And I think the original coroners, and the word is derived from the Latin for crown, were representatives of the crown and there to protect crown assets. But one of their jobs was to investigate deaths. And so if somebody died unexpectedly or suddenly or unnaturally in a town or a village, then it was a duty of the citizen to raise the hue and cry and go and find the coroner and tell them. The coroner would then decide whether or not to investigate. And if the decision was to investigate, they do so, and they call witnesses and so on. But the roles develop separately from the judiciary. So coroners aren't members of the judiciary; they're not judges, although they sit in courts of law. And their role is developed completely separately. And so 30 years ago, when I came to the bar, or 26 or whenever it was a very uneven service. You would have coroners paid completely different wages depending on which local authority they worked for. Some would be very formal, some would be very informal, and it was a very inconsistent jurisdiction. And there have been a number of changes recently that I'll come on to, but there's been an attempt to try and draw the coronial system together. There was a chief coroner was a role that was created in 2009. And that is a circuit judge or a high court judge whose job it is to be the head of the coronial service and provide consistency in training, provide law sheets on giving advice about law and procedure and so on. So it's become a much more professional, much more consistent sort of a court. But really the reason it's changed so much, I think fundamentally in the last 20 or so years, is the Human Rights Act in 1998. So the way in which the Article 2 procedural obligation, or the investigative obligation, in other words, the state has a duty to investigate properly deaths that occur in state custody, that will very often fall to the coroner's court. Because, for example, if a prisoner dies by their own hand and they suspend themselves with a ligature and die in a prison cell, there's obviously not going to be a criminal case. And so there's no opportunity, if it wasn't for the coronial system, there's no forum in which that death and the circumstances of that death would be investigated. And so it's been dolloped on the coronial system like a massive dollop of ice cream. And it's a court that was probably not that well suited to it at first. We still had doctors with no legal background who were sitting as coroners a few years back. Now you have to be a lawyer. And I think understandably they were finding it difficult being confronted by QCs arguing about European law and the convention and so on. So it's become quite legalistic and quite complicated. But essentially, it's the investigation into deaths. So if you die quietly in your sleep and it's an expected death and you're suffering from an illness that your GP has been treating for you for the last few days, there's obviously not going to be any report to a coroner's office. But if somebody dies unnaturally, then that usually triggers a reference to the coroner's court. So what does the coroner do? The coroner just receives lots of referrals, and they have to sift through them and work out which they're under an obligation to investigate. And then
these referrals, do they come from private people? You can just write a letter and say that you want the death to be investigated.
Anyone can write to a coroner, but typically, of course, they come from doctors, because most people will die. Very often people will die, if not in hospital, they'll have medics attending them by ambulance, and so you'll have paramedic involvement and so on. But if somebody is discovered dead at their home and there's a suspicion or somebody's been missing, and the police investigate and find a body, then it's the police that make the referral. So it's by far the most common route of referral is via the police or via the Coast Guard or via hospitals. But no, there's no actual limit. I mean, if a coroner were told about a death that might need investigation, then the coroner would consider it. They wouldn't ignore it.
So let's say, I mean, we're in the middle of the COVID. Well, I shouldn't say the middle, but we haven't yet left the COVID pandemic.
Yes.
And let's say there are, I don't know how many people, but let's say thousands of people who dispute that there is any COVID. And so if someone were in hospital, for example, and they die and the hospital says, we think this was COVID-19, but their family are ardently against the very concept of COVID-19. They think it was the masts with the telephone signals. Is a decision by a coroner in one city who says, I'm not going to investigate this case. I'm happy with the conclusion that the hospital gave, saying that it was COVID-19. Is there any kind of precedent that goes into that, if there were thousands of the same questions being asked in different cities? Or would it require individual coroners to look at and reply to every single such application?
I think the short answer to that is that the coroner would be led by the evidence and follow the evidence. So with COVID-19, very often you'll get no referral because somebody will develop COVID-19 and die as a result of that, or with perhaps other contributing underlying features. But that would typically be a natural death. The COVID cases that are coming into the coroner's courts that I've seen are ones where there's been an accident. So you'll have, and this is a typical case, you'd have an elderly person with mobility problems who's taken a fall at home, and they might have, for example, broken the neck of their femur. They're brought into hospital and they're obviously in pain and they're treated, and they may develop pneumonia and they may develop COVID-19 whilst they're in hospital. Now, the reason for that referral would be the fall, because that's the unnatural part of the death. But yes, I think we're very much led by the evidence. So there's a lot of false negative testing going on. And in some cases, you have doctors saying, well, we know this person had a broken leg and we know this person had pneumonia. We think she probably had COVID-19 too. I would be a little bit chary about that, because we don't really deal in possibilities generally, we deal in probabilities. So if you'd really want to get to know, find out and get evidence as to what the probable cause of death was, you can, and it's perfectly all right to add with possible COVID-19. So if somebody definitely had pneumonia, you could make a finding on the balance of probabilities that the cause of death, the medical cause of death, was was pneumonia with possible COVID-19. I don't think saying possible COVID-19 as a medical cause of death would be acceptable, because if the evidence isn't sufficient for you to make that finding on the balance of probabilities, it's probably not a legitimate finding. But no, in terms of pressure groups and that sort of thing, I don't think coroners are immune from that sort of thing. But I think, unless there's proper evidence in front of the coroner that an investigation is required, then I don't think you'd get anywhere with it.
Okay. So you were saying what happens then after the referrals come in? What's the next step of the procedure?
Well, it really depends on what sort of a case it is. So if it's somebody who's fallen at home and broken their leg and they're elderly, and they develop pneumonia and there's no real question about all of that, then usually you can proceed to a quick an efficient inquest, and that usually benefits the family. The family, need to be kept hanging around for as little as possible. They need to get the death certificates out, and they need to be able to move on with their lives. And there's no need to delay things if you've got good evidence from the hospital. Contrast that with a case where, for example, somebody is being restrained in a prison and they die of asphyxiation as a result. It may be that there is a criminal investigation. It may be that the Crown Prosecution Service have a period of time where they decide whether or not to bring any criminal convictions. And so that can cause enormous delay. And what happens to the inquest is that it is put on pause whilst that happens, and then resumes if necessary after the criminal case. So if there's no criminal case, then there will be an inquest, because the state needs to investigate the circumstances of death in some forum, and there's not going to be a criminal case. If there is a criminal case, sometimes there is also an inquest following on, and I've got an example of that happening in the near future. So it really depends on the kind of case. So you can see immediately that there can be delays of years before an inquest. I'm about to start an inquest into the death of a number of people who died when a tram toppled over and resulted in multiple fatalities. And there have been enormously detailed investigations that have already gone, which means that we're only picking up on the inquest years later. And it's not ideal when memories have faded and that sort of thing. But they can be extremely complex coroner's cases, and take years and years and take hundreds of witnesses. Or they can be very straightforward indeed and be dealt with on the day that they arrive in the coroner's court.
And you mentioned the possibility that there may be criminal litigation surrounding the story that you would be looking at as a coroner, or civil litigation about someone's liability. So does a coroner's decision impact in any way on subsequent litigation, and vice versa? Does a judgment from one of the common courts impact on a decision that an inquest would make?
Well, that's a really good question, and it requires a careful answer. The coroner's court, whether it's being determined by a jury, and there are some cases, for example, death in custody has to be determined by a jury. The facts have to be determined by a jury. But whether it's a jury or coroner, what juries and what coroners are not allowed to do is express themselves in a way that suggests civil or criminal liability. So the coroner's court is an inquisitorial court, rather like some of the continental European court systems, where the coroner leads the investigation and calls the evidence that he or she needs in order to find out the answers to the statutory questions they have to answer. But of course, there is an impact in this sense that if you have a loved one who dies in hospital, and if you believe, or if there's indeed evidence that might have been the result of medical negligence, there's a temptation on the part of the family and their representatives in the coroner's hearing before the civil case to try and get as much useful information as they can. Now, to some extent, that's legitimate, and insofar as it's trying to establish what the facts were, that's fine. But going further than that and trying to pin the blame on an individual doctor or a named person or a named institution is really outside the coroner's jurisdiction, and that's when a coroner would have to step in. In the coroner's court, what parties are not supposed to do is have a case. The advocates representing, for example, an NHS trust or a prison or a family are not supposed to come with a case that they want to prosecute. But of course, very often it's the family's first opportunity in a court of law to air their grievances and their concerns. And so there is a lot of push, particularly on the part of families, and to some extent it's understandable. That means that rule is really honoured more often in the breach than the observance, because what the family are very often is very angry and they want answers. And so what they do is they instruct their lawyers to cross-examine witnesses in circumstances where you're not supposed to do that in the coroner's court. It's meant to be a neutral, objective investigation into the facts, and you're there to assist the coroner, not to put a case. So there's a lot of push and there's a lot of pressure on coroners, and really it has to be, it's a difficult balance to strike, because what you don't want to do and what you shouldn't do is have the families feeling that their point of view is not being listened to. But at the same time, a coroner is a creature of statute and has limited powers, and you can't stray into areas that you're not legally entitled to look at. So it's a tension, and it has to be managed carefully. The best way to manage it, in my experience, is first of all with a smile, a friendly smile, and explaining just honestly and openly to families the restrictions that you're under. And if you do it in the right way, they're usually pretty understanding.
What are the possible verdicts that a coroner can give? Is there a finite number of possible results?
No, we used to call them verdicts. We now call them conclusions. And the reason for that name change wasn't just window dressing. It's because there's an attempt to move away from the association with a criminal conviction or a civil wrong having been done. So the conclusion is a more neutral word that we use now. And what used to be called short form verdicts were a list of conclusions or verdicts that the coroner would arrive at, and typically there would be accident, suicide, misadventure, open verdict, and that sort of thing. Now, we still use those short forms, and they're very useful in the right sort of a case, because there are people that look at the coronial records for the purposes of statistics and public health, and it is useful to have categories so that people doing research can understand what the big picture is telling us. But we now, in addition to that, we also have what we call a narrative verdict. And a narrative verdict is simply a brief, neutral description of what happened. And so, for example, where you have death in custody, where there's been a hanging in prison, quite often it's just not enough to have a neutral statement of the facts and then a single word conclusion. There needs to be more. And if there's been a breakdown in the system of inspection or the system of monitoring prisoners and that sort of thing, then that can, again, in the right case with the right evidence, be incorporated and included within the conclusion. So we still have those short form conclusions, and they have a place and they're quite useful. But we also, in our armoury, have this narrative verdict where we can do a bit more explaining.
You mentioned that coroner's inquests adopt an inquisitorial as opposed to an adversarial style. Do you think that, with you being a barrister, you've obviously have an enormous amount of experience of the adversarial system, and as a coroner you have experience of the inquisitorial system. Do you think that either of the approaches is more or less likely to arrive at the truth?
Well, I work in an adversarial system, and it's been said before by some wit that the adversarial system is built on the notion that the headlong clash of lies somehow produces the truth. Now, I don't really go along with that. I think it's a bit too cynical for me and a bit too simplistic. Well, there's no doubt it's not a perfect system, but I'm not sure there is any perfect legal system anywhere in the world. When it's done properly, I'm not sure there's any better system, and I think it does have advantages over the inquisitorial system. I think for coroners who are there to establish facts, they have a relatively limited jurisdiction. There are specific questions that they have to find the answers to, and I think there the inquisitorial system works rather well because it's led by the coroner. The coroner has no interest in the outcome of the inquest. All they need to do is establish the facts and on the evidence decide what the most appropriate conclusion to draw is. And I think if you had parties trying to twist and turn it one way or the other in those circumstances, it may be a less efficient and less useful role. But when it comes to deciding, for example, the area that I work in, the resolution to civil wrongs, it seems to me that it's advantageous to have the parties who investigate, who prepare their case, who advance the case in the best way that their client wants them to advance it, because there are things that they have to say, there are arguments that they want to make. There may be arguments that they don't want to make for particular reasons and perfectly legitimate ones. They might want to put their case in a certain way. They might want to emphasize certain points. And it's difficult, I think, if you've got a judge taking the lead in an inquisitorial system, to have that, to have the ability to understand the client's case. The advantage of the adversarial system is that the two advocates get in the ring and they give it their best shot, and you have the impartial judge, referee and judge really, determining the case at the end of it. So the process of the adversarial trial is completely different. You have the testing of evidence, and cross-examination might not be a perfect way to test a witness's evidence. But again, I've not come across a better way of doing it. And in the right hands, it can be done very, very effectively indeed. And then having had the opportunity to cross-examine the other side's witnesses, you then have an opportunity to put a credible spin on it in your closing submissions to the court. And the judge then goes and thinks about the competing submissions and comes up with their answer. Now, that's the hard bit. But as a system of producing a system of arbitrating between disputes between people in the civil arena, I think we've yet to develop a better system. I think it probably is the best that we've got.
Mm-hmm. Mm-hmm. Now, just before we come on to talking about advocacy and the regular or common courts, just returning very briefly to the coroner's court. You mentioned that juries are sometimes involved in inquests. And that made me wonder whether, do the same rules of evidence or procedure apply to inquests that we would be familiar with from the common courts? And when would juries take part, and when would they not take part?
Well, there are certain circumstances in which a coroner has to sit with the jury. So an example of that are deaths in prison.
Mm.
There are some cases where a coroner can choose to call a jury, and that might be there might be perfectly good reasons that a jury is thought to be important, or that a jury should determine the facts in a case. And there'll usually be cases involving the state, but not always. The differences between them are really that the jury are the arbiters of fact, and the law is for the coroner. So what the coroner's role changes in a non-jury inquest. The coroner is both judge of fact and the judge of the law, and the coroner will direct himself or herself in accordance with the law and the rules. Where there's a jury, the jury are the fact finders, and so they'll only be present in court when evidence is being given, mm-hmm. and when the coroner at the end of the case or at the beginning is giving them directions. So the jury then are sent out while legal arguments take place. So they take place in the absence of the jury. And the argument might be whether a certain witness should be called. The argument might be what areas ought to be covered, what areas are legitimately within the scope of the inquest. Once that's been resolved, the juror will come back in and the evidence will continue. The really big difference between a civil trial and a jury inquest, or indeed a criminal trial and a jury inquest, is that advocates cannot address the jury. You are not allowed to make submissions in front of a jury. So you cannot, the rule is there to prevent advocates trying to persuade a jury as to what factual findings they should make. Mm-hmm. That's entirely for the coroner to direct them on. So the role of the advocate then is pared down to simply asking questions. When the jury are in the room, you're asking questions of witnesses and then sitting down. And when the jury are out of the room, you're making submissions to assist the coroner but prosecute their inquest.
That's fascinating. I've learned a lot. I didn't know very much about coroners' inquests at all. So I feel like I've learned a lot, and it's made me want to discover more about it. But I can't let you go just yet without talking about the other aspect of your, perhaps not day-to-day life, but certainly a very important aspect of your professional career, is teaching advocacy. You're a member of the advocacy training team of Inner Temple. You're a senior advocacy trainer. That means you train beginner advocates, experienced advocates, and people who are going to go on and become advocate teachers, trainers themselves. How do you respond to someone who says, Pele was born with that magic inside him, Chopin had that creativity? You can't teach someone to be a great advocate any more than you could teach them to be a great pianist, artist, or footballer. What do you say to that?
Well, I think it's very difficult. I think you have to accept the limits of advocacy training, and what you can't do is teach somebody to be a Picasso or teach somebody to be a Mika Hakkinen. You can teach them to do a reasonable approximation of a drawing, and you can teach them to drive a car so that they don't have a crash. They drive on the right side of the road. So I think you've got to start with reasonably modest ambitions. The advocacy trainers can't create the very best advocates for everybody. But what they can do is teach you the basics, so that you won't look like a fool when you stand up in court. That you get the basics right. That you understand what your role is. That you understand the order in which things should be done, and that you have a reasonable idea as to how to present your case in the most effective way. All of this really comes from the great George Hampel from Australia. He's really invented modern advocacy training, and it's been adopted all over the world. And what he's come up with is well, his light bulb moment really was understanding, I think, that advocacy is a performance skill. And like any performance skill, it can be improved with training. There was an idea that obtained previously, which is very much along the lines that you were describing, that it was thought that advocates are born brilliant, that they pop out of the womb spouting Shakespeare, and the effortless brilliance that was the sort of traditional sort of English idea. People working terribly hard under their covers at night, working for their exams, and then the next day pretending that they hadn't done any revision whatsoever. It was all rather silly, and we've got beyond that, I think. But George's idea was why can't you teach advocacy in the same way that you might teach, for example, sport or any other skill? And he broke it down into a system that has proven extremely effective. I mean, it's undergone changes over the years, but it's still at its core the system that he developed. And the system is that you pick out one aspect of a person's performance. So you watch them do a practice advocacy exercise. You pick out one aspect of it that could be done better. You tell them what that aspect is in a sort of short, pithy phrase. For example, if we take the sporting analogy with skiing, don't lean backwards when you're skiing. You then show the student what they did. And in a skiing example, I suppose you would ski in front of them leaning backwards so that they can see what they're doing. You then explain to them why it's important not to lean backwards. And you explain that if you keep your weight over the front of the skis, you have more control. Crucially, you then tell them how to fix it. You give them a technique, try and lean forward with your head over the tips of your skis. And then finally, you demonstrate it to them. So if that's the skiing example, in advocacy, you might watch a performance and you might say to the advocate, don't explore in cross-examination. So that would be your single point. You would then demonstrate to them by reading them verbatim what they said in questions and the rather unhelpful answers that they got from their witness. You would then explain to them why it's important not to explore because you lose control. You then give them a tip as to how to get control, how to get over that problem. So having run through all of those training points with the student, then from the trainer's point of view comes the hard bit. You have to demonstrate it to them. And what you're supposed to be doing is showing them how it has to be done perfectly. And of course, it's not always possible to achieve that. But the idea is that you give them a demonstration, a short demonstration of how to do it and how to put that training into practice. And as I said, it's proved itself to be a very, very effective method of training over the years. You're not turning out Picassos, but you are turning out people who can turn out a reasonable watercolor, I think.
And do you find that having sat, as it were, on the other side of the bench as a coroner, do you find that being the recipient of the advocacy rather than the deliverer of the advocacy has affected the way in which you assess what good advocacy is and what things are persuasive and what are not?
Yes, I mean, I think one of the traps that advocates sometimes fall into is being rather obsequious and constantly referring to the judge as my lord or my lady over and over again. And actually, one thing I have noticed is that, and this is from the bar and talking to judges, is that judges don't really like that, or at least the good judges aren't bothered by people being obsequious and calling them lordship, your lordship, over and over again. And the bad judges, it just makes them worse. I think probably the best way to deal with it is when you stand up on your feet and you address the judge, you'll say, my lady, I appear on behalf of X. My learned friend appears on behalf of Y. But after that, I don't think you need to keep repeating your ladyship over and over again. I think it can be quite distracting when you're a judge. And certainly being obsequious doesn't help. As I said, the good judges don't listen to it, and the bad judges, it just makes them worse. The other thing really comes back to something I touched on earlier, which is just don't be afraid to get on with it. I think that there's an enormous amount of time flapping about with what some people call unnecessary verbiage, and I think there's nothing wrong with just getting to the point, and I think most judges welcome it. Fantastic.
Well, I'm really looking forward to seeing you again. I hope that we'll be able to invite you to come and visit us at one of the British Law Centre locations. Thank you so much for having found time to talk to us today. It's been really interesting, really good fun as always. So Scott Matthewson, thank you.
Thank you very much, Steve. Take care.
Take care.